See that? A duty of candor. As an attorney is first an officer of the court, bound to serve the ends of justice with openness, candor, and fairness to all. Now, we may all scoff at that, but that came out of the rules regulating the Florida bar, and it's right here. Clear as day. You see that? The duty of candor imposes an obligation on counsel to notify the court of any development that may conceivably affect the outcome of the litigation. And I would know this if I just hadn't developed a reason not to trust anybody, like Stone Cold told The Rock, DTA. And there you go. And here's where we are in my case, which was a case that I found that was really intriguing. And you see, I'm going into Florida because I'm in Florida. Although an unintentional non-disclosure involving no intent to deceive cannot constitute fraud, a compromise may be invalidated for fraud if one party deliberately conceals facts with the intent to induce the other party's action. And also, don't just take out the snippets, read the whole case. Like this class, it may seem like watching paint dry, but it's valuable information. If the fraud occurs in connection with misrepresentation, statements, or omission which cause a party to enter into the transaction, then such fraud is fraud in the inducement and survives as an independent tort. And a tort is just a cause of action, people, for those who don't know. And by the way, when they say plead with specificity, you got to show exactly what they did. A knowing misrepresentation of truth or concealment of a material fact to induce, and misrepresentation made recklessly without belief in its truth to induce another to act. So by saying, hey, we're here to talk about the Tuckers, yet you really do this for the purpose of trying to secure or to limit the liability and exposure for your other client, or for not even your clients, because don't forget, he didn't represent the other parties.